Okay, welcome everyone. We'll make a start a little bit late, so thanks for bearing with us. I'm Alan Andrews. I'm the Climate Program Director at Ecojustice Canada. I am one of the co-hosts. The other co-host is joining us from Brazil via Zoom. So we're going to start with him, Caio Borges. Caio, are you there?
Yes, can you hear me or can you see me?
We can hear you, but we can't quite see you yet.
I don't know if the
No,
other.
there you are. There you are. Over to you.
Oh, okay. I was going to ask if the other panelists can see me. So yes, thank you very much, Alan and Alessandra, for being there. And also I'd like to say hi to the fellow panelists and all those who accepted the invitation. So Sophie and David and Julia, this is a pleasure to have you all here. I'd like to thank the organizers of the Climate Law and Governance Day for accepting this proposal to have this discussion on which I think it's one of the hot topics, yes, in climate law and policy and also in climate litigation these days. I just wanted to start by again just greeting our panelists and also by saying that the motivation behind us proposing and suggesting this panel is that we are seeing so many developments in different jurisdictions in climate reporting rules. And also we are seeing developments as well in enforcement action against greenwashing. And I think we have here representatives or people who are working in jurisdictions where regulatory oversight agencies have been taking actions against misleading, deceiving, incomplete, insufficient statements. So the first thing I would like to start with is by saying that greenwashing is this multi-dimensional and multi-conceptual issue by which a company, a corporation can engage in this malpractice, not just by, deliberately misleading investors or consumers, but I would also like to remind us that if the information concerning the companies or the corporate commitments, plans around climate change, if they are also incomplete, if they are ambiguous, if they lack the proper clarity for investors, consumers, society to understand exactly how the company is taking real action to decarbonize its business, then this could also amount to greenwashing rules. I think Alessandra will perhaps give a quick, we'll go over Brazil, but just wanted to say that since this is a panel again with people coming from different jurisdictions, I think we're going to have a rich discussion here. Just to say that at this point in time, Brazil is one of those jurisdictions where regulators have been adopting mandatory disclosure rules. And our Brazilian Securities and Exchange Commission now requires listed companies to disclose their climate risks on a type of comply or explain basis. And again, the motivation to propose this panel is to learn from other jurisdictions how civil society, how lawyers, how different actors have been somehow pushing the corporates to comply with the rules, because the first studies and assessments of how companies have disclosed their climate risks points to a very patchy landscape where many companies, they are simply stating, very generic things about the issues that they are facing, transition and phasic risks. So this is very generic and it's not applied to the reality and the circumstances of that specific company. And we do even have, according to the first analysis of the first round of disclosure of the corporate filings, companies that have not even complied with the rules, so have not even disclosed altogether any climate risk. So this is something that we need to discuss again from the perspective of how to ensure compliance, on how to ensure that, you know, there will be consequences for those who are failing to comply with the rules, and any challenges for, you know, the proper implementation of the rules, and also the trends that we can see worldwide in this area. Quick note, Brazil has also adopted, I think, the first jurisdiction, but also on a voluntary basis, the IFRS standards on corporate sustainability, S1 and S2. Unfortunately, it came on a voluntary basis, but I think this is a step that shows that this is something that I think almost all agencies that are overseeing the markets, they are now taking care of. So with that very quick note, Ellen, I will hand over back to you, and thank again for the organizers and the panelists for this incredible discussion.
Thank you. And so you might have gathered this is a Canadian-Brazilian co-production, but we also have a panel comprising folks from Australia and the UK. So we have a pretty good global perspective. As Caio said, the issue of greenwashing is absolutely front and center in the climate world. In my adopted home of Canada, greenwashing is everywhere. It's absolutely rampant, with corporates and financial institutions making pretty meaningless commitments to net zero without credible plans to achieve those targets. My organization, Ecojustice, represents a group of complainants who have submitted a Competition Bureau complaint regarding Canada's largest bank, the Royal Bank of Canada, for making a net zero commitment without such a plan. However, I can only look on in envy at other parts of the world where lawyers are really taking to the courts to address this problem directly. They say you should never meet your heroes, but I'm delighted that I will have a few of them on the panel here today. And these folks are those who are really at the cutting edge of climate law, making law directly through the courts, which, if any of you have been following the painstaking negotiations taking place at COP, is a welcome change in pace from what we're seeing here. People absolutely at the coalface, making law on the key issue of our time. So I'm going to hand over at this stage to Alessandra. Welcome, Alessandra, and thanks for keeping me company in real life.
Can you hear me? Thank you, Alan. It's a pleasure. It's a pleasure to be here during CLGD, which, as I just mentioned in the previous panel that I just chaired, has built a reputation as the largest legal event happening at COPs. Definitely given us something to look forward to. So today, I have the task of briefly introducing the topic with regard to Brazil. But for context, I will make some general remarks as to what's going on globally. And before I do so, I just wanted to say that I absolutely agree with Caio with regard to his opinion that the topic of this afternoon's panel is definitely a hot topic, no pun intended, when it comes to climate law. So, and it's definitely not nearly discussed as much as it should be. So I commend you on proposing this topic, and I'm very happy that we're able to have such a geographically diverse panel today to tackle this fundamental issue. So when it comes to disclosures and greenwashing, I would say that the gist of the idea is that at the same time we have more and more disclosure requirements stemming from several sources, as Caio just mentioned, and two, disclosures that used to be voluntary are now increasingly becoming mandatory. So with a heightened degree of disclosures comes, of course, increased scrutiny. of information that is made available by companies. So as a result, there is, I would say, a more robust basis for enforcement. And since this is one of the key themes of our panel, and a more robust basis for greenwashing litigation. So basically, more disclosure means more information, and more information means shedding potentially more light on greenwashing. So with regard to the flourishing of rules that I just mentioned, this has been happening globally in two fronts mainly. So first, there has been a significant rise in unilateral climate measures with cross-border effects on global value chains, most of them stemming, as we know, from the European Union. But there is also indication that other countries may follow suit. And this is, of course, very relevant for Brazil, particularly as a commodities exporter. So the impacts of these unilateral rules are very key for countries like Brazil. So, and the second front is that besides those developments, we are now witnessing a flourishing of sustainability and climate reporting standards, both mandatory, such as the CSDDD, CSRD, and the SRS, all from the EU, and voluntary, such as the ISSB, S1 and S2, that are also affecting actors along global value chains, and Brazil is, of course, no exception. So I would say that this creates a perfect storm of sorts that is due to illicit responses from countries that want to preserve their competitiveness, particularly from large exporters of commodities, as I said, that will necessarily reverberate across corporate activity. So in Brazil, we have already noticed some responses to the wave of regulation that I just mentioned, albeit quite timid. One such example that comes to mind is the issuance of a self-regulatory rule by the Brazilian Federation of Banks, comprised of most large commercial banks operating in the country, an initiative that was later joined by the Brazilian Development Bank, stating that pretty much they will no longer finance meat producers involved in illegal deforestation. And of course, we also have the autonomous rules mentioned by Caio, the comply or explain climate risk and opportunity disclosure requirements that have been issued mainly between 2021 and 2022 for public companies, also covering the financial market, and finally, insurance companies. The rule for insurance companies in Brazil is particularly interesting because it mandates insurers to also account for the risks of climate litigation, and so it's probably a first. In Brazil, it's definitely a first in that sense. And also with regard to Brazil, and I'm moving towards my concluding remarks, it's very interesting to note that greenwashing litigation, both judicial and administrative, has been flourishing around the world. I'm sure our other brilliant panelists will cover several examples, but not so much in Brazil. And this is something that is, I get asked about a lot, and this is something that's somewhat counterintuitive, considering our litigation culture that we have in Brazil. We tend to take things to court pretty often, and we also don't have the same procedural hurdles as other jurisdictions do. So issues of standing, of access to court, and costs related to bringing a case to court are relatively easier to comply with in Brazil. So I think it will be very interesting to see if moving forward, this will start to change when we have more disclosure requirements actually entering into force. And finally, as this panel subject prompted us to do, I think another matter to keep track of is the subject of materiality. So we have at least one example of climate litigation in Brazil, which is based on double materiality, which is the ClientEarth case that challenges the Brazilian Development Bank's equity portfolio, both in terms of whether it is a sound investment and in terms of its impacts on climate. So I think it will be interesting to see if different standards of materiality impact climate litigation or not. I would also like to say before I conclude that interoperability among standards is still pretty low, despite initiatives to try and improve this. Meaning there's still a lot of room for conflicts and for overlaps among different requirements. And while and I think this is really key, the European initiatives adopt a double materiality standard, the ISSB framework's pretty much settled for a single materiality. So in Brazil, the ISSB has already been endorsed by the CVM, which is our securities authority, and the Federal Council of Accountants. So what I think is adopting single materiality affects enforcement and litigation prospects in the way that I said at the beginning. So perhaps there will be less information available to scrutinize, but I don't think this affects the core climate arguments that can be produced before a court. So meaning that challenging the activity's impacts on climate will, I think, remain possible. Thank you.
Thank you, Alessandra. Sorry, I'll switch to my other mic. So our next speaker is Dr. Benjamin Franta. He's a senior research fellow in climate litigation at the Oxford Sustainable Law Programme and the founding head of the Climate Litigation Lab. His research focuses on applying rigorous methods to practical challenges presented by climate litigation worldwide. So he's pretty perfectly qualified to talk to us about the bigger picture when it comes to climate litigation. I'll also note that for an unusual trait for a lawyer is that he has a scientific background among his many impressive legal qualifications. He also holds a PhD in applied physics from Harvard. So over to you, Professor Franta. I should, sorry, it was remiss of me as chair to say the broad format we're going to take is opening remarks from each of our panelists, and then we'll break into more of a sort of discussion Q&A format, and really hoping we have time to take some questions from the floor. So as you're listening to our speakers, please do think of some good questions to ask at the end. Dr. Franta, over to you.
Thank you so much, and hello everyone. It's great to be here, and you know, it's really great to have this opportunity just to lay out some of the broad issues in greenwashing. As mentioned, I am a senior research fellow at the University of Oxford, and I lead a research group that's focused on conducting research to inform climate lawsuits around the world. So we have more of a litigation focus, but greenwashing is one of the major areas of litigation we see growing around the world. And you know, first I want to put in context why it's so important that we focus on this, because sometimes we might think about greenwashing as being relatively minor and, you know, it's the harm that it does or something like that. But actually in historical context, it's extremely important. You know, before I became a lawyer, I was a historian of science, focusing on climate science, among other things. And one of the most important things that has been learned in the last decade is that greenwashing was an essential part of the incumbent oil and gas industry's strategy to delay fossil fuel controls all the way back from the late 1980s. So a few years ago, there was a strategy memo discovered. This is from 1989, given to the board of Exxon. And it was all about how to delay legally binding controls on fossil fuels. And the strategies developed were basically threefold. One was to argue with climate science, deny climate science, and insist that it wasn't certain enough yet to take action and that we needed more research. And that history is very well documented by now, and I'm sure probably most of you are familiar with at least some of that history, especially the heyday of climate denial in the 1990s. The second prong was more of an economic prong that's actually not very well known among many, people in the climate world, but it was one of the essential prongs of the incumbent strategy was to make climate policy look too expensive to implement and to downplay the economic costs of climate change itself. And we can also see this strategy implemented through the industry's hiring of economic consultants and things like that. So that's sort of an interesting secondary strategy that the industry deployed. And then the third, which is most relevant to greenwashing, is that the incumbent companies knew that to ward off legally binding controls on fossil fuels, they would need to propose alternative solutions that would make it appear as if the problem of global warming were being addressed. And the first three alternative solutions that the industry identified and started to promote, which were designed to keep fossil fuels dominant in the marketplace, were one, promoting natural gas as a climate solution, and that I'm sure is still quite familiar to many of you. Two, promoting efficiency as an adequate solution to global warming, and three, promoting carbon offsets. And that might be also surprising, and that's still a very live and timely issue. But all the way back in 1989, in this internal strategy memo, carbon offsets were one of the main strategies the industry identified for preserving the fossil fuel market while making it appear that the problem of global warming was being addressed. And we know that this strategy was communicated to fossil fuel companies all around the world by 1990 and implemented by them. And so already by the time of the UNFCCC agreement in 1992, the incumbent industry was ready with this strategy to weaken and delay legally binding fossil fuel controls. So that's just a little bit of historical context to illustrate why, this issue of greenwashing, and when I say that, I include, promoting solutions that actually are not effective at solving the problem of global warming and promoting them as effective to the public, that has been a central pillar of delaying progress on solving this problem since it became a political issue over 30 years ago. We also know from historical research that by the end of the 1990s, the incumbent industry moved away from its, heavy climate denial prong of its overarching strategy and leaned more into the greenwashing component and things like that. So by the year 2000, that's when we see a bunch of other solutions that are pretty non-threatening to the dominance of fossil fuels enter the picture. Things like carbon capture, hydrogen, which is almost all made from natural gas, and biofuels as well. So that's a really interesting aspect of this history. So we're really in this age of greenwashing that has been going on for over 20 years now. And so, that it makes it sort of even more important that it's addressed, because insofar as it's used to delay effective solutions, that's irreversible damage that is done to, the entire world, nature, and its societies. So, that's just, I think, some table setting to understand why it's so important. Now, where do we see this action in litigation? There are some really interesting things happening in Europe and the UK. We're seeing new powers for the Competition and Markets Authority in the UK that can include steep penalties for misleading consumers about products, as well as the new proposed Green Claims Directive in the EU, and that's also really interesting. A lot of the litigation that we're seeing that directly addresses greenwashing is occurring right now in the United States. And these are these actions are based mostly on state consumer protection laws. And these laws are very broad. They essentially prohibit any sort of unfair or misleading communications, business activities or communications to consumers. So that includes statements that might technically be true, but are presented in a misleading way. So that includes material omissions, misleading, contextualizations of facts, and so on. So we're seeing those actions being brought right now. Right now, there are about 40 ongoing suits against carbon majors, mostly in the US, being brought by governmental entities like states and cities. Some of them are for damages for climate change. Some of them are under these consumer protection statutes, and some of them are both. They're blended, dual type claims, and so those are very interesting because one, the bar for success for the plaintiffs in terms of the standard of proof required is not very burdensome. In some cases, the plaintiffs do not need to show damages from greenwashing, and they don't even need to show an intent to deceive on the part of the defendants, and they might not even need to show essentially materiality to consumers. That varies by state, but in some instances, it's all they need to do is prove that a statement has a tendency to mislead a consumer. So that's a pretty low bar, and arguably a lot of green related claims and communications and ads and so on fall under that category. And in addition to injunctive relief, essentially ordering these companies to stop making those sorts of claims, these laws also provide for civil penalties that can add up for every violation. And so that could easily get into a steep civil penalty, monetary penalty for the defendants as well. So, there are stakes to these cases. Now, what are some of the issues substantively that we see being litigated essentially in these cases? Well, as I mentioned before, one of the major issues is promoting fossil gas as low carbon. We're also seeing more scrutiny on carbon offsets and promoting things as carbon neutral. There's a consumer class action ongoing right now in California against Delta Airlines for allegedly misleading consumers about carbon neutral flights. We also see some attention being placed on allegedly misleading promotion of biofuels as a solution to climate change. A great example, just as a fact pattern to analyze, is ExxonMobil's algae biofuels campaign, which ran for about 10 years, but the company never had an algae biofuel product. The promotion of hydrogen is probably going to receive a lot more scrutiny going forward because not only is almost all hydrogen made from natural gas, so it actually releases greenhouse gases as it's produced, but there's a growing understanding that hydrogen is an indirect greenhouse gas itself because it increases the atmospheric lifetime of methane. And hydrogen, of course, as the smallest molecule in the universe, is very leaky. So that, those are big problems facing hydrogen promotion and marketing, and more scrutiny on carbon capture being presented as viable, scalable, and ready to go in here. And then we have the brand advertising, and this isn't really so much about products being promoted, but about the whole brand. So we see a lot of advertising that just promotes a brand as sustainable and green. Sometimes it's implying that the company's investing a lot in renewable energy when the company might, in fact, not be. Sometimes it's just green themes. So there will likely be a lot more scrutiny on that as well. And of course, the carbon neutrality claims. So those are just some of the substantive topics that I would expect are going to be litigated going forward. Now, what about future directions? Just to kind of wrap this up. One of the impediments to litigation in the space has traditionally been a lack of data and data transparency. So in terms of advertisements, it's actually very difficult to see what is being advertised. A lot of advertising is focused on, it's tailored through social media, kind of profiles and algorithms to particular individuals. So there's not a lot of visibility on that. So that's something that's being addressed currently by some of our researchers at Oxford and other places as well. So I would expect there's going to be much more transparency in this space going forward. And that's going to enable a lot more journalistic scrutiny as well as litigation and regulatory activity. There's increasing legal attention on some of the so-called enablers of greenwashing. These might include creative agencies or advertising agencies that create these misleading advertisements, and what are their legal liabilities and responsibilities? What do they look like? More attention placed on investor-facing greenwashing. So think about all those investor calls, all those proxy statements, all those annual reports. I sometimes I read through investor call transcripts, and I regularly see questions like, what are you doing about climate change? And the answers are often, oh, don't worry, we're investing a lot in clean energy and low carbon energy sources. And then that might be demonstrably misleading if you go back and see that actually they're not investing that much, or they don't really have a plan for moving away from fossil fuel reliance. So that's another interesting area. And then, just to kind of integrate the litigation and the regulation, I think, the litigation will bring to light many of these issues, and then some of those standards that are developed might be folded into regulations that, apply more broadly. So I think there's going to be this synergistic interplay between litigation and regulation to address and counteract greenwashing going forward. So that's just sort of an overview of the space, and I look forward to the discussion. Thank you very much.
Thank you. And I certainly see all those greenwashing techniques that you've described there on display in Canada, and also on display at COP. If you walk around, you will see lots of greenwashing techniques being advertised as the future solutions to all our problems. So with that overview, we're going to zoom back into a particular jurisdiction, and that jurisdiction is Australia, which if you're one of those sad people who spends their life looking at climate litigation around the world, you'll have noticed that Australia has been having a bit of a moment, and I suspect a big part of that is down to our next speaker, David Barnden, and his colleagues at Equity Generation Lawyers. I won't go into any more detail on David's credentials. Safe to say he's been behind some of the most exciting cases in climate litigation around the world, and I'm really looking forward to hearing his perspective on this topic. David, over to you.
Thank you, Alan. It's nice to be introduced as potentially a focus of sad people, but here we are. Thank you for the introduction. Yes, I work for a very small law firm called Equity Generation Lawyers. We're about 4 years old. We're stacked with very clever class action and corporate lawyers, and we've done a range of things in the past, from duty of care cases against government decision makers on behalf of children for not approving new coal mines, to pension fund trustee duties cases, and we've recently filed a case against our export credit agency on its scope 3 emissions and reporting against those. But today I might just touch on 3 greenwashing or greenwashing related cases that we've been involved in. The first deals with something that Ben brought up as a part of the fossil fuel strategy on delaying regulation, and that's to downplay the costs of climate change. So in 2020, we filed a case on behalf of a young investor in sovereign bonds, and she alleged that by not disclosing the material impacts of climate change to the economy, investors such as herself were being misled by not having the full suite of information about material risks. Now, this case was not liked by the government, I think it's fair to say. And so after about 3 years, we still hadn't got to the evidence phase, and it settled recently in October. As a part of the settlement, the Australian government published a statement acknowledging that climate change was a systemic risk to the economy, that ratings agencies were looking at sovereign bonds and climate change, and that investors, interestingly, were engaging with the government on policy settings. So it provides an interesting foundation for engagement. But it wasn't just the settlement. Because it was a class action, the settlement was approved by the court, who provides an oversight role for the unnamed members of the class, being people who purchased these sovereign bonds, and they were sovereign bonds that did mature in 2050. So we're talking quite long-term durations of these bonds. And Justice Murphy of the Federal Court delved into what the applicant would have needed to prove, and we see this building some of the jurisprudence in Australia. So he said it seems likely that such events, being climate change impacts, will give rise to a huge drain on Commonwealth resources and on the tax base over a very lengthy period, perhaps forever, and therefore also weighs on the forecasts in relation to the Commonwealth's financial and economic position. So we've got some really strong statements from the judiciary with respect to sovereign bonds and overall economic impact. So that was a species of greenwashing case. It was brought under misleading or deceptive conduct provisions as they applied to financial services. The second case, again, deals with financial services. That's been resolved. It was two shareholders inspecting the books of Australia's largest bank, the Commonwealth Bank, on the basis that they were concerned the bank may have been misleading shareholders as to its promise not to finance new oil and gas projects unless they were in line with the goals of the Paris Agreement. And in fact, it did finance no fewer than 7 projects. And that was a shareholder rights case. The inspecting the books mechanism is, there are analogues in Europe and in the US, and it's used not just to investigate potential misconduct of greenwashing variety, but also directors' duties. So it's a really good tool that shareholders have. That case wrapped up with the court in April giving us permission to use a raft of documents for future proceedings. And since that time, in August, the Commonwealth Bank came out with a new policy, a dramatically improved policy, which categorically ruled out direct finance for all new and expanded oil and gas extraction projects, as well as some critical enabling infrastructure, such as pipelines to new oil and gas fields. So we see this sort of interest in greenwashing being accessed by shareholders, not on a full-on misleading or deceptive conduct case, but on an investigation basis. And we do have now a really good policy from the bank, and we have probably less than $2 billion worth of fossil fuel financing in the market as a result of these policies. Now, finally, the last case is a new one we filed in the middle of this year. This is pure greenwashing, and again, it goes to a point that Ben brought up around the strategies of promoted by Exxon back in 1989, which is offsets. And so we are suing an energy retailer, energy utility, if you like, called Energy Australia. It's the third largest energy retailer in Australia and one of the largest polluters, because it's not just a retailer, it actually creates its own energy from burning coal. And that case is a case saying it cannot promote its energy as carbon neutral by virtue of an offset system, which is primarily avoidance offsets. So you have a company burning coal to create electricity. You have offsets, which are avoidance. So it might be things like financing wind farms in the future to avoid emissions. But we break it down as, emissions, 1 plus 0 doesn't equal 0. So this is not carbon neutral. And an interesting thing about this case is that the company relies on a government mandated offset scheme, and that scheme is currently under review to potentially remove those carbon neutral statements. So I might just leave that there as a bit of a taster from Australia.
Thanks, David. So sadly, I've been told that we need to wrap things up in the next 10 to 15 minutes, so we better move things along pretty quickly. So with that, I'll introduce our next speaker, who I had the privilege to work with when I was lawyer at ClientEarth. ClientEarth is an international environmental law not-for-profit. Sophie leads the Accountable Corporations leads the Accountable Corporations work at ClientEarth, which focuses on strategic litigation and other legal interventions to drive governments and companies towards reducing their greenhouse gas emissions in line with the Paris Agreement. Sophie, I'll hand over to you. Really looking forward to hearing your take on how you're tackling greenwash at ClientEarth. I've been enviously watching the many cases that you've been bringing over there. Over to you.
Thanks so much, Alan, and thanks to the other panelists. Lovely to see you all, and hello to the people in the room, although I cannot see you. I'll just keep this to 5 minutes because we're running out of time. So I think I agree with everyone's comments, particularly Ben's comments, that essentially greenwashing is the new climate denial. And we see that very clearly in our work on corporate disclosures. Unfortunately, despite greater disclosure of risks of climate change to the world's largest companies, we've seen limited corresponding action to shift to low carbon business models. And clearly, and our research has shown that reporting is patchy and uneven and selective across companies and sectors. Strategies that companies use in their reporting to make net zero claims, for example, have been pointed out, including unreasonable reliance on false solutions such as offsets, cherry picking of pathways, caveating of goals on society's progress, and a fundamental, simple refusal to acknowledge any responsibility for Scope 3 emissions. Those are some of the issues that we are starting to unpack in some of our consumer law litigation. And I'll just whip through some of our cases. We have a large portfolio of greenwashing work, but I would just want to make the distinction. There is a really important distinction between financial regulation and its regulation and consumer statement and advertising statement regulation and its regulation. So although statements made by companies in those two spheres to their shareholders and to the general public are often linked and often tend to use the same messaging, they are distinctly regulated. And in the former, with financial regulators, we've seen the very limited enforcement, except for in Australia. The ACCC in the last year has come on board, which is lovely to see. But in the UK, we've had very limited enforcement of any regulation from the FCA to date. And in Europe, again, the new taxonomy, etc., is bedding in, and there's this sort of period of implementation. But we haven't really seen so much enforcement yet. Whereas in the consumer law space, happily, consumer law regulators are quite adept at grasping the zeitgeist and tackling these new greenwashing trends and issues that come through in corporate advertising. And so that's where we've seen huge action over the past 12 months from consumer law regulators. And frankly, in a lot of our work, we've been working with those consumer law regulators, and it's been an absolute pleasure to work with them. And we've got many new guides that have come out on greenwashing. We've also had in the EU a complete transformation of the and reform of the Unfair Consumer Practices Directive, which is the overarching consumer law for Europe, specifically to tackle green claims. And so the issue of offsets will no longer, companies will no longer be able to rely on offsets to make carbon neutral claims in the next 12 months. So I think we've probably hit the high point of environmental marketing, to be honest, at least in Europe, given what the reform to the UCPD means for corporate advertising of green claims. And especially there's another piece of legislation proposed called the Green Claims Directive, which would require companies to actually audit the claims that they make in their advertising before they put that to the market. So these are huge changes, and we have been in rooms with PR and marketing folk who have said, we just don't know what to do. I'm sure, however, that they, being the incredibly clever and adaptable people that they are, they will figure something out. But we are in a period of huge regulatory change, at least in the consumer law space. But there's still, the problem is so vast that, of course, there remains issues, and we tackle that through our cases, through our litigation. Currently on foot, key cases that will come up next year includes one in partnership with Greenpeace France, Notre Faire à tous and Amid la Terre against Total Energies. And this is a claim about the veracity of that company's claims to consumers to be moving towards net zero and to be transitioning itself to be a major player in the transition and reducing its emissions to zero by 2050. We say, in contrast to its continued investment in gas, and all of those issues that I previously raised will come up in that case, including reliance on cherry-picking pathways, inclusion of scope 3, caveating of goals, and the company's reliance on offsets and biomass. And that's why consumer law is such a fascinating tool, because you can actually potentially have a factual dispute on the facts of these claims, whereas when one looks to financial regulation, that's often a subjective and material assessment that is really, that's why financial regulators tend to leave those judgments to the companies, whereas in consumer law, the test is, what does the average consumer perceive and believe when they see the advertisement? And so we are able to raise some of these fundamental factual issues. And that will come up, as I said, the French Total case next year. We're also in court in 19 days in the Netherlands against KLM. And again, this is a really fascinating case that I think shows how important advertising and controlling the narrative is to corporates, and how equally important it is to hold them to account, because KLM put out a very expensive advertising campaign a few years ago, encouraging their customers to fly responsibly with KLM. For example, consider taking the train before you choose to fly. Consider packing a lighter suitcase. Consider flying with us, where you can buy a CO2 zero product, which is a carbon offset with your flight that will contribute, make a contribution towards your emissions. And also it offered customers the chance to buy or contribute to sustainable aviation fuel. Now, that case is really at its heart about what consumers perceive from that marketing, and whether in fact KLM is on the path to a sustainable future. And it's really interesting to note that in its annual reports, the company commented that sustainability advertising and sustainability was crucial to its business because that provided it with a license to grow. So it could see that flight shame, that issues around people choosing not to fly anymore because of climate change, etc., had the potential to impact its business model, and therefore the campaign was calculated to get ahead of the game and to co-opt that conversation and to control that conversation. And we know that this works. This has impacts not only on the general public who think that the problem is being dealt with by companies, but it also has an impact on regulators who see the same advertising as we do, and also therefore think that that effective regulation is not required because companies are dealing with the issue. So voluntarism doesn't work, we would say, and it also is fundamentally a flawed strategy. What we need to see is really a move from disclosure to action, and that's why we are putting a lot of effort into seeking mandatory transition plans to be included in the CSDDD, which is the Corporate Social Responsibility Due Diligence Directive, currently in discussion with the Council of the EU, where we hope to achieve strong mandatory provisions on transition plans that include all scope emission reduction targets and would actually require companies to put these plans in place. And if we can achieve that, we hope we will have a model for global corporates to actually align their businesses with the goals of the Paris Agreement. Thank you.
Thank you, Sophie, especially for speaking to us a few weeks before court. We'll be looking out really closely for those cases, so good luck with them. I did have some questions, but they've been anticipated and answered by our panel, so I'll hand straight over to our audience to make use of the 3 minutes that we have left. Does anyone have any questions? Oh, okay. 2 minutes, so make the questions quick.
I'll try to make the question what I think. So CCS. So the narrative of CCS on the one hand is one that it's being portrayed as one of the miraculous technologies, and we have put a lot of expectations on it. However, the role on CCS on unabated fossil fuels is not clear. Moreover, the definition of abated fossil fuels is not clear either. Would that fit, the question, would that fit as a case? Would that fit as a law case? And if not, what is missing to make it fit?
So if I understand the question correctly, it's, could you base a case on this term unabated fossil fuels?
Yeah, that's one part. And the other part is governments and companies pushing forward CCS as the fast-tracking, credible, and orderly technology that is going to take us to the energy transition. To me, that's a big claim. And on the other hand, is the lack of a clear role of CCS on that transition and the missing of a clear, credible, blah, blah, blah definition for abated fossil fuels. Could that make the law case? And if not, what is missing to make it fit as a law case? Thank you.
Thank you for the question. And my general stance with regard to climate solutions is pretty much whatever works. I would say that we need all the help that we can get, all from a scientific and technological standpoint, and also from a regulatory point of view. But I think when it comes to CCS, this, as pretty much everything else, carbon markets and regulation and litigation, everything is pretty much just a part of the puzzle. CCS will be to be effectively a part of the solution. As we know, we'll have to, as for it to be scaled up, it will have to become both scientifically and technologically viable at a large scale. And I totally agree with you. So I think we risk missing the forest for the trees sometimes, and whichever solution that is touted as miraculous is probably and most certainly not. So I think we should consider things for what they are, a part of the solution, never as a one-size-fits-all solution that can be touted as your question mentioned, as a miraculous solution.
Do we have time for any more questions?
The Dubai plenary is at 4:15. So no, we don't.
Okay, well, thank you everyone, and thank you to our wonderful speakers.